Well, good afternoon. My name is Ivan Griscti. Welcome to Level 22 Chambers. Thank you for joining us this afternoon, whether you've joined us in person or here in this room or alternatively online. At the outset, I would like to acknowledge the traditional custodians of the land on which we meet and are transmitting from, the Gadigal people of the Eora Nation. I pay my respects to elders past and present. This afternoon, we're proposing to have a presentation and discussion in respect of two very recent High Court cases. The first of these, which the discussion will be led by my colleague Allison Silink, will be focusing on the decision of the High Court from last month, AA versus the Trustees of the Royal Catholic Church for the Diocese of Maitland-Newcastle. It's an historical abuse claim that was determined by reference to the issue of non-delegable duty. The second case, Hunt, Leather and Transport for New South Wales, decision of the High Court from December 2025. It's a case essentially sometimes forgotten tort of private nuisance, with particular reference to a claim being brought against a statutory authority, and I will lead the discussion on that issue. So to start off the discussion on the AA decision, I'll just introduce Alison. Dr Allison Silink is an academic member of Level 22 Chambers. She is an associate professor in the Faculty of Law at UTS, having previously come from the School of Private and Commercial Law at UNSW. She teaches and lectures in many areas of private law. She also has relevant to today, particular expertise in addressing institutional liability, and regularly makes submissions on matters of law reform, has been consulted on draft legislation in the course of law reform in New South Wales. Alison, I'll hand it over to you to discuss the decision of the High Court in AA and consequences of that judgment.
Thanks very much, Ivan, and thank you everybody for attending tonight. For those here this evening and also online, I believe you've received a copy of the slides that I've prepared. You'll see that they're a lot longer than I will attempt to look at individually in the course of speaking to them tonight, but the aim was to give you a fairly comprehensive summary of the relevant passages in the judgment and some other resources to supplement the discussion that we have tonight. So just starting here, I just want to put the discussion this evening in the context. I think the decision of the High Court in AA in relation to non-delegable duties really has to be understood in the broader context of institutional abuse law and the potential pathways for claimants in seeking compensation from an institution in relation to historical abuse. So, as many people know, there are really three pathways that might be considered for a claim, being vicarious liability, negligence, or the non-delegable duty. But all three of those have historically and continue to be beset with difficulties that make claiming compensation not necessarily straightforward. Vicarious liability, as people know, vicarious liability is a tool of public policy that allows the law to render an institution liable for the wrongdoing of another. It's not grounded in any particular tort. It applies to intentional torts, it applies to negligence, but it has one critical limitation, which is that it has been limited to employees, and the opportunity that the High Court had 2 years ago in Bird and DP to consider expanding that scope for vicarious liability to wrongdoers who are in a position akin to employee was not taken by the High Court. So there's over a decade's jurisprudence embedding this concept of akin to employee in the United Kingdom, but Australia, the High Court closed the door, leaving vicarious liability only available in the context of employees. It was only, in fact, exactly a decade ago in 2016 in Prince Alfred College that the High Court accepted that vicarious liability did lie for intentional wrongdoing such as sexual abuse. So it's limited by the type of worker. Negligence has been notoriously difficult to prove in historic abuse cases, requiring evidence of the awareness at the time and what a reasonable person at the time would have done to address the risk, and that evidence is often very difficult to establish. The third pathway is the one we're talking about tonight, which is the non-delegable duty. A non-delegable duty of care, as I'm going to speak generally about the nature of that duty, but in essence, it is a personal liability. It's not a form of vicarious liability. It's a personal liability on the institution to ensure that reasonable care is taken, and it's a liability that cannot be discharged by delegating functions to an independent contractor, which is a defence that would be available in relation to an ordinary duty of care. Non-delegable duties arise in very special classes of case that are characterised by vulnerability and control over the person to whom the duty is owed, such as schools, the duty owed to students, hospitals, the duty owed to patients. Employers owe a similar duty to employees in the workplace. Now, in relation to the institutional abuse context, this has been a pathway that has been firmly blocked since the decision of the High Court in New South Wales and Lepore, where the majority held that a non-delegable duty applied to negligence, and by negligence they were referring to harm that was not intentionally inflicted. And as we all know, the really significant thing about the AA decision is that it has reversed Lepore and now extended the non-delegable duty to respond to intentional wrongdoing. So just by way of general comment, I just want to say that for us as lawyers, we understand the doctrinal limitations of these various doctrines and the historical reasons for them, but for the public, for families dropping their kids to a childcare centre or dropping their children to school, understanding the legal rationale for why the liability of an institution would depend on whether the wrongdoer was an independent contractor or an employee or a volunteer or whoever may be there on a day is very challenging. It's very difficult to explain. So the scope of what I want to do today for our purposes is just speak very briefly to the historical context in relation to non-delegable duties, to put in context the High Court's reasons. I then want to look at the particular facts of the case and the reasons in relation to the nature of the duty, its extension to intentional wrongdoing, and the scope of the duty, all of which are important. As I said, there is more in the slides than I will necessarily cover today, but you'll see the important passages. And then I want to look at what I think are three important questions that this all gives rise to. One is I think there are going to be real questions in how we define the scope of this duty, and in particular, the distinctions and or overlap with vicarious liability, and how the scope of the doctrine of vicarious liability appears to be more limited or limited by further considerations than the scope of the non-delegable duty. So that it may be that at the moment, following AA, where a non-delegable duty applies, there are fewer hoops to jump through to demonstrate that the institution should be liable than if it were a case of vicarious liability. That leads to, these questions aren't in any particular order, but I want to look at the relationship now between the non-delegable duty and vicarious liability, in particular in light of a couple of decisions, or one in particular that's considered the non-delegable duty since, in which a non-delegable duty was considered in a school context. Obviously, schools are a classic case for vicarious liability, and it was regarded by the New South Wales Court of Appeal that now that the non-delegable duty applies, it applies to any delegate which embraces employees. So it really leaves a question that's not considered in the AA, which is the doctrinal questions and developments in Prince Alfred College in extending vicarious liability to wrongdoing by way of sexual abuse of employees. Is Prince Alfred College, what was the remaining relevance of Prince Alfred College? And if we have a case where abuse arises in a school context or in any other relationship to which a non-delegable duty applies, if the wrongdoing is by an employee, which is the heartland of vicarious liability, do we bypass vicarious liability now and go straight to a non-delegable duty analysis? I think these are some big questions that remain to be answered now in relation to the interaction of those two doctrines. And that leads then to a final question, really, which is about the coherence of tort doctrine and negligence in particular. What impact does this decision have on the law of negligence generally? If our analytical pathway is that the non-delegable duty is a duty owed, is a duty of care owed in negligence, and the non-delegable duty of care owed in negligence can now be breached by intentional wrongdoing, does that mean that the law of negligence generally is now to be breached by intentional wrongdoing? The well-known phrase is an act done negligently or intentionally. What does that mean? If the implication of AA is that negligence is to be understood as extending to intentional wrongdoing. So that's the scope of what I want to look at. So just by way of brief background on the nature of the development of non-delegable duties under Australian law and where things stood before AA. AA has come in a line of cases, all of which have given very detailed and focused consideration to the scope of non-delegable duties. The principles that we get from those cases that are not controversial are that the non-delegable duty is a personal and direct liability. It is not a form of vicarious liability. It is a duty of care owed to ensure that reasonable care is taken, whether that whether that care is or whether the functions are in the hands of the duty holder or any person to whom it's delegated. It's the accepted categories, and those have by design been carefully monitored and limited, arise where there's been an assumption of responsibility or control, particular vulnerability in the person to whom the duty is owed, and generally a lack of choice about the conditions in how they are treated. So unconscious patients on a table in a hospital, children in a school, for example. It's not an absolute duty, but it's very clearly a duty that can't be discharged by the selection of an independent contractor. And prior to AA, the most recent statement and consideration of the nature of a non-delegable duty was in Pathburn, where the plurality there said that a non-delegable duty is a type of care which, if owed by a person, means the person cannot exclude or limit their liability for conduct within the scope of the duty of care causing reasonably foreseeable harm. So it's all the language of negligence. It's a duty of care owed in negligence, but it cannot be excluded or limited by arranging for another to perform the functions to which that duty of care relates. So previously, the cases that I put on that timeline have confirmed this non-delegable duty as a duty owed in negligence. And it being a duty owed in negligence that's characterised by these particular features of vulnerability or control to warrant limiting the defence of discharge by the appointment of an independent contractor. And certainly the indications in these cases did not seem to lead to its application to intentional harm. Either the non-delegable duty or negligence generally. So these cases, even Prince Alfred in 2016, there the majority spoke of the difficulty that common law courts have had to identify the circumstances in which an employer should be held vicarious liability for negligent acts, let alone intentional or criminal acts. So the court there seemed to distinguish between what constituted a negligent act or a intentional criminal act. That was then directly considered in Lepore, as we know, where the majority held that that the non-delegable duty did not extend to intentionally inflicted harm, because whilst intentionally inflicted harm is obviously a legal wrong, there are other legal ways to address intentionally inflicted harm. And Justices Gummow and Haynes said that to extend it to intentionally inflicted harm would remove the duty altogether from any connection with the law of negligence. So that's the background. And I think one of the things that's important, I think, to bear in mind in this history of the scope of negligence and non-delegable duties is to remember that the distinction was being drawn between negligence and intentionally inflicted harm, not intentional acts. We all know that I can intentionally kick a ball and accidentally break the window. It's not the issue is not whether negligence or non-delegable duties extend to intentional conduct. It's the intentional infliction of harm that was at issue. So that brings us to the case itself and what the case has found. So this was a case where where in brief summary, Father Ronald Picken was a parish priest within the Diocese of the Roman Catholic Church in Maitland-Newcastle. He had the plaintiff, AA, in the original proceedings, alleged that he and a friend met Father Picken at first at school, but he was the parish priest, and he had invited them back to the presbytery on Friday nights to smoke cigarettes and drink alcohol and to play his pinball machine, which was located next to his bedroom. From the evidence of AA was that he had been abused by Father Picken on a number of these Friday night evenings. These were not official church events. They were at his personal invitation to come to the presbytery and socialise on a Friday night. The primary judge, Justice Schmidt, found that the diocese was vicariously liable and liable in negligence, and the trustees appealed. And in the New South Wales Court of Appeal, Justice Leeming, with whose reasons Chief Justice Bell agreed, found firstly that the fact finding had miscarried, those being the factual findings of abuse and the findings on which the duty of care had been found. Justice Leeming found that the vividness of the plaintiff's testimony and reliability of that testimony was not sufficiently tested, and that no duty of care existed in 1969 on the part of the diocese. Justice Ball disagreed that the fact-finding process had miscarried, but agreed that no duty of care was owed, and the appeal then went to the High Court. 3 grounds of appeal, but the most significant was the question whether Lepore should be overturned and whether the scope of non-delegable duty should be recognised as extending to intentionally inflicted harm. Now, in relation to the findings on that duty, the plurality found that the duty was owed to a child to ensure that while the child was under the care, supervision or control of a priest, as a result of the priest purportedly performing a function of the priest, reasonable care should be taken. And the reasoning adopted the analogy with the school setting, and there was said there was no meaningful distinction to be drawn between a school and a priest. One of the questions that came up between the majority and the judges in dissent was whether on the facts of the case, these Friday night gatherings actually represented a function that had been delegated to the priest, and whether there was any meaningful care, supervision or control in inviting 15, 16, 17-year-old boys who came of their own volition and were entitled to leave when they wanted. Justice Gordon similarly found that the risk of injury in the care of a priest gave rise to a non-delegable duty, and that the diocese appointing Father Picken and expecting him to engage with young people as part of his ministry defined the functions. And this is something that is important because it represents a different lens of analysis of these cases to the vicarious liability approach, which takes a much narrower view of what are the functions of a priest. Justice Edelman described the duty as a duty owed to those who are invited onto diocesan premises and again in the care of the priest in control. The two judges of the High Court in dissent, Justice Stewart, said that the duty, accepted that a duty would arise, but that it was confined to occasions when contact was authorised, permitted or required. So took a narrower view of the functions that were given and that it did not arise in this case. And Justice Gleeson said that the relationship between AA on the facts of this case and the diocese did not involve the diocese tasking a job or taking a job or task for him, by which they assumed a responsibility for the priest's exercise of that task. There was simply no function of the diocese in that in the circumstances of the case. So this, I'm not going to go through this in detail, but you can see how the questions give rise to I think there are real questions now about how we define the scope and also apply this scope as set out in the reasons in the High Court to the facts of a case. The scope of vicarious liability, of course, is limited by a course of employment test, and in the context of sexual abuse, whether the wrongdoing was whether the functions given to the wrongdoer were the very occasion for that wrongdoing or merely the opportunity. And I think the tension that arises now is whether, by describing the function of a priest as to engage with parishioners in any way, whether that elides this concept of opportunity or makes it difficult to distinguish between what is a mere opportunity and what is a specific occasion that would give rise to liability. Now, interestingly, what seems to be one of the consequences of this case is that clergy abuse under Australian law is now seen through the lens of non-delegable duties, the delegation of functions to a delegate of a school, church, whereas under UK law, clergy abuse is dealt with through the lens of vicarious liability, that a priest is akin to an employee. So we now have clergy abuse being dealt with in two quite different doctrinal pathways. I'll finish up very soon.
That's all right, Alison, as long as you need.
So I won't go through these reasons on scope. You've got them there in the handout. But I do want to take you to this recent consideration of non-delegable duty in St Paul's College and Allen in the New South Wales Court of Appeal. This was a school case, so it ordinarily would be dealt with as a garden variety vicarious liability case, the duty owed by a school to a child. Ordinarily, it would be dealt with under the principles in Prince Alfred College and ADC, liability for abuse arising in the performance of functions as a teacher. In St Paul's College and Allen, Justice Kirk gave the judgment, with whom Justice Payne and Acting Justice Price agreed. It was largely a pleading decision, but Zona said that in a non-delegable duty case now following AA, All a claimant needs to plead is that they were a student in a school, so that the defendant school body owed them a non-delegable duty of care, that the duty was breached, where it suffices to allege that they were abused by a teacher, and that the abuse occurred at a time and place within the scope of the defendant's duty, which caused harm. So you can see that this analysis is a much simpler lens through which to look at abuse arising in a school context than the Prince Alfred occasion and considerations of opportunity to have intimacy, control, vulnerability, all of those factors. There was no discussion as to whether Prince Alfred College remains the way through which these cases should be considered, but it was assumed in the New South Wales Court of Appeal that non-delegable duty now covers the field for employees as well as independent contractors. Under UK law, to illustrate the divergence, under UK law, the non-delegable duty arises when vicarious liability ends. So where there is no opportunity for vicarious liability because of the employment relationship, that is the non-delegable duty arises for independent contractors and others. So the other part that I've included in the paper is a review of the authority supporting negligence applying to intentionally inflicted harm. So I've summarised the evidence that is in the case, but I've summarised some of the references that have maintained a distinction between intentionally inflicted harm and unintentionally inflicted harm as a division in tort law. The only authority mentioned by the plurality is a reference to a case of McInnes and Wardle. In fact, that case was a case about a rabbit fumigator who was tasked with fumigating a paddock, and he had been told not to light fires, but the usual ways of getting rabbits out of holes in the 1930s was to smoke them out. So he lit a fire that he shouldn't have lit, much in the way of that old case. Remember the tanker driver who threw his cigarette butt at the service station and blew up the service station. Non-delegable duty arose, but the point that I want to make is that this is a distinction between an intentional act. So he intended to light the smoking machine. He was not an arsonist. He was not intending to cause harm, an intentional infliction of harm. So this case, in fact, with respect, does not support the previous law extending to the intentional infliction of harm, and nor do the other authorities cited. So, look, I want to finish up there. As I've said, the non-delegable duty, there are now questions in relation to how the non-delegable duty is going to operate alongside vicarious liability. I've referred to the St Paul's College and Allen's case, and so I think these there are real questions now about whether the non-delegable duty, or rather the reasons in AA, extend to negligence generally. Does negligence generally now apply to intentional wrongdoing? And I think careful thought is going to have to be given to the relationship between these different doctrines. Sorry for going over.
No, not at all, Alison. Look,
that's where I'll leave it.
I should say I'm going to give my presentation. It's fair to say mine is not. My case is not as perhaps big from a broader sense in terms of discussion points well, certainly there's less discussion points than Alison's. But there should be some time for some questions. If you're online, I believe that you can. You're presumably at our YouTube YouTube channel. You can probably type in your questions there and they can be relayed to us. If anyone has a pressing question now, feel free to share it. Otherwise, we can wait until I've done my presentation. I might have one or two questions from a point of view of a legal nerd. I think a really interesting aspect of the judgment is really sort of what you more or less finished up on, Alison, that notion of the basis upon which the High Court essentially justified, if that's the term, finding that non-delegable duties apply to intentional acts rather than, what we understand to be mere acts of negligence. So that's an intriguing point, but there's no one in the room is putting their hand up at the moment. So let people ruminate on what they may wish to ask at the end. This is me. As you can see from the slide, it's all about the light rail. And I know the light rail, you might remember, if you're a Sydney-sider, that for what seemed a goddamn eternity, George Street, Anzac Parade was a construction site. And that's really the source of this. How do you get to be Chief Justice of the High Court? It's if you have the ability to succinctly say what a case is about in the first sentence of your judgment. Chief Justice Gageler says, this appeal concerns the liability to neighbouring landholders in private nuisance at common law of a public authority exercising statutory power to procure public works on public lands. So that's what this case is about in a sentence. So it is a case about private nuisance, but more particularly on the specific facts in the context of works conducted by a public authority. Before we delve into the particular facts of this case, I think it's useful to touch upon the elements of what constitutes private nuisance. And this is really a lot of the members of the High Court in the decisions went through the authorities, and this is as distilled by the High Court. The elements there, first of all, you've got defendant's use of land so as to cause substantial interference with the claimant's ordinary use of the land. And then private nuisance is established provided one or two of the following: that the defendant's use was not a common or ordinary use, or if it was a common or ordinary use, then that use was not conveniently done, that is to say, without proper consideration for the interests of the relevant claimant. A lot of the authorities and the ones that they refer to, and indeed a number of the judgments, make reference to it necessary for there to be unreasonable use. And the concept of unreasonable use seems to be, based on my analysis of the judgment, seems to be built into that notion there of whether the use was not a common or ordinary use. So inbuilt in that is the concept of reasonableness, but reasonableness in a different sense from what, like, for example, in a tort law way, but it's reasonable use. I'll touch upon the facts of that as we go through it. And so just briefly, the facts: Transport for New South Wales, statutory corporation that planned and procured the construction of the Sydney Light Rail. It was supposed to be completed in March 2019. There were extensive delays. It was not completed until March 2020. It was supposed to be done in stages, and so that there were occupation periods for each fee zone, they were called, establishing under the relevant project deed. The intention of the strategy was to minimise disruption to businesses along the route. This failed dismally. The businesses were subject to extensive construction activities in excess of what was anticipated. So the appellants, the two appellant parties, one was Hunt Leather, the other was a company called Ancio Investments. They owned businesses that were impacted upon by the project. So they were the lead plaintiffs, essentially, on behalf of other businesses, other persons claiming loss as a result of the substantial interference with the enjoyment of their land. Hunt Leather, you may know of it. It's a fancy leather store in, I think it's Strand Arcade, close to George Street. Anchio Investments owned a restaurant in the heart of Kensington on Anzac Parade, and that was a real mess down there in particular. I think it seemed to occupy, just by way of example as to how the impact that the building had on, at the level of disruption, let's put it that way. The construction work on George Street near Hunt Leather was extended by about 500 days, more than it should have been. The construction work on Anzac Parade near was a Thai, it's just strange because it was a Thai restaurant, then it became an Italian restaurant, but maybe it was a change of tenants. That's a by the by. It was extended by about 800 days in that area, so it was ridiculous. So it was a nightmare. You can see one of the judgments, I think it's the judgment of Justices, sorry, that's right, Gordon and Edelman provides details of the nature of the inconvenience, but you know, there was dust and dirt and barricades, and employees were sick from all the impact. It was shocking at the impact on them. Brief history of the litigation. First comes before, incidentally, my favourite common law judge, frankly, Justice Kavanagh, and he found that there was an entitlement to private nuisance established. The Transport for New South Wales appealed to the Court of Appeal, and the Court of Appeal allowed the appeal, finding that no nuisance had been established. So then there was obviously we end up before the High Court, and there are 4 separate judgments. They're not identical, but they all ultimately arrive at the final position. And when you look at them, Justices Gordon and Edelman, not strictly, I think, the principal judgment, but that their judgment has the character of being a principal judgment. If you were going to read one of the 4 judgments, that's probably the one you'll read, I think. But, and as I say, they're not identical, and we'll touch upon how there are some differences. But just going through, again, in not great detail, the relevant elements, which you might recall from the earlier slide, of the elements of what constitutes a private nuisance. Substantial interference. This was straightforward. In fact, it seems to have been conceded by TFNSW that in planning and procuring the light rail, there was a substantial interference of the enjoyment by Hunt Leather and Anchio Investments, on which they conducted their businesses, and those businesses were use of the land that was for ordinary purposes for the particular land in their locality. So element 1 is satisfied. On we go. Then look at the next question. The construction of the light rail procured by Transport for New South Wales held to be not common or ordinary. And so this subject of a good amount of analysis by the court. Again, as I say, the question of reasonableness feeds into this, but in dealing with what's common or ordinary, there was a discussion as to, well, you know, you've got a statutory corporation here. On one, it was argued by Transport for New South Wales, construction works are common or ordinary use, and the response from most of the bench was, well, yes, if it was, you know, regular roadworks, maintenance, that sort of thing, that is common or ordinary, but construction of a light rail, not so much. Actually, Justice Beach-Jones disagreed with the rest of the bench on this issue. He actually thought it was common or ordinary. And he sort of goes through an analysis, and he said, well, you know, we've had trams for a long time. It's just construction of trams. So I'm going to say that it is common or ordinary. in a sense, so dealing with the sense when we're looking at, it's interesting to think about the evidence that was led by the plaintiffs / appellants on this case, and dealing with the issue of common or ordinary inbuilt in that the question of reasonableness, and we know whether their actions were unreasonable in that context. An expert witness gave evidence essentially saying if this even allowing for unforeseen events to happen, and even allowing for things like a lot of the problems were caused because of difficulties with what lay under the ground, and I guess it's when you're constructing a light rail, it's not a matter of simply doing a dial before you dig inquiry. There's perhaps a bit more to it than that, but in a sense, so this, even if you're half competent, this expert more or less says once the construction went past a certain point in time, it became unreasonable. And that evidence was not in any way countered by Transport for New South Wales. So once that evidence was on, that was really the only evidence on that issue. And from the point, once you hit a point in time, it became unreasonable. So the construction of the light rail was reasonable to a point, but because it took so long, then it became unreasonable, and there was no contra evidence. And look at some interesting cases as to what constitutes ordinary, common or ordinary. And some of the facts of these cases are quite amusing, and most of them are not necessarily recent ones. There was a case of Cleary versus the Principal and Council of the Women's College. It's 1953 90 CLR 170, and that case essentially, the neighbour of the women's college was complaining because apparently the women at the college were very noisy, but the court held, well, it's a women's college. What do you expect, mate? That was the gist of the judgment. So that was nothing in terms of the ordinary, the accommodation of university students. It's to be expected, it's ordinary usage that they would keep late hours and in the course of doing will make such noises, apparently in the judgment. So it's also a great case from about 1972. It's unreported, decision of Justice Strait before he became Chief Justice, a case of Fisher versus Cadelpha, and pops up in big cases. And that it's great because it's got a magnificent Sydney eastern suburbs vibe to it, because they were building the eastern suburbs, the railway, the Bondi Junction railway, and this person who lived in Woollahra objected to the fact that they were going to use some dynamite to to actually build the railway. Anyway, Justice Street on that said, look, and dynamite doesn't happen any day, but for the purpose of constructing a railway, would consider it ordinary, common or ordinary. But look, moving on then, so that subject to the Justice B. Jones decision, view on the issue, those two elements meant that private nuisance was established. Justice B. Jones, however, did find that private nuisance was established because the next question he answered in the alternative question, the construction was not conveniently done. And again, so he, in that context, I think was very much reliant on the evidence that, well, these guys went way over time. It was not reasonable. It wasn't conveniently done. So, and it was the onus shifts on that issue. The onus is on the defendant to establish that it was conveniently done. As I said, they didn't have any evidence to counteract the expert evidence which was given as to how long it should have taken reasonably to construct the light rail. Sorry, I pressed the wrong button there. Relevant to just think of a couple of defences in this case, and these are defences arising from the fact that we were dealing with a statutory authority. And so Section 43A of the Civil Liability Act, we're dealing with, it's a section that applies to proceedings where liability is based on a public or other authority's exercise or failure to exercise a special statutory power conferred on the authority. And there's a definition there of a special statutory power being a power conferred under a statute of a kind of persons generally are not authorised to exercise without specific statutory authority. The key part of this section is that for the purpose of such proceedings, any act or omission involving the exercise or failure to exercise a special statutory power does not give rise to civil liability unless the act or omission was so unreasonable that no authority having the special statutory power in question could properly consider the act or omission to be a reasonable exercise of that power. All along the way, in this case, it was held that this special statutory power, this section doesn't apply because the relevant special statutory power was not being exercised by Transport for New South Wales. That is to say that the relevant acts or omissions giving rise to the nuisance, being the actual construction work, was not being exercised by Transport for New South Wales. They were its contractors that were doing that work. They were procuring it, they organised it. I know it seems like quite a pedantic distinction, but so they weren't exercising the special power that gave rise to the liability. So that failed. Then secondly, there's a defence of statutory authority, again, only available if you are a statutory authority. It's a defence to a claim for a nuisance if the creation of the nuisance can be shown to be the inevitable consequence or reasonably necessary from the exercise of a statutory power. And this is picking up on an analysis that we've discussed earlier relevant to what the expert evidence established. But they essentially said, well, this defence was partially established once Transport for New South Wales established the period and manner of asserted unreasonable. Sorry, I think there's a slight error in that PowerPoint, but the gist of it being that the evidence, once it was established that from a period of time, its exercise of power, the way it was undertaking the works, were no longer reasonable, it had the onus of establishing that its conduct were reasonably done. So essentially, so the nuisance was the inevitable consequence of the exercise of its statutory power, but only to the extent that they did the works for a reason. They were managing the works for a reasonable time. Once you got beyond that point in time, then it was no longer the inevitable consequence or reasonably necessary, because and as I say, the expert evidence was unchallenged on that issue. They had not produced any evidence to counter it. So there was a partial success on that defence, but as I say, once we reached the point in time, well, went to a certain number of days, then from there onwards, that's where their liability lies. Damages have not yet been assessed, and the case is going back for assessment of damages. But one issue, and one final thing, one issue that came before the court on was whether, because the plaintiffs said, well, look, we've been sent impecunious by these events. We've had to procure litigation funding to bring these proceedings. We want to claim as damages the reasonable cost of litigation funding. And at every step of the way, that's been rejected. So High Court has said you cannot include reasonable litigation funding costs as damages. So that's really the discussion there. It's an interesting case because you don't see many private nuisance cases, and it's also interesting from the perspective that, as I say, it's brought by a statutory authority, and there were certain parts along the way where the relevant onus is reversed, and for example, in terms of demonstrating that beyond a certain point in time, particularly in the context of the defence of the statutory authority, that its actions were an inevitable consequence or reasonably necessary in the exercise of the statutory power. Now, that's really the discussion on that case. I'd certainly like to invite any questions, whether it's towards Alison or myself. Jackie, have you got a question from the online situation?
I do. It's an online question. Did the court consider any public policy issue regarding the reasons cases like Lepore had restricted non-delegable duties to negligent acts?
Oh, sorry, Jackie, I thought you were directing that to Ivan.
Apologies.
Sorry.
Did the court consider any public policy issue regarding the reasons cases like Lepore had restricted non-delegable duties to negligent acts?
I will have a look at the reasons. I don't recall specific discussion of public policy as a reason. The court went through the factors in Johns for why and the circumstances in which the High Court will reverse an earlier authority, so approached it more through a doctrinal lens. To the extent that there was a question, to the extent that those factors include a question of whether the case has caused any broader, I've forgotten the term now, caused any broader inconvenience, then the court the majority was satisfied that Lepore should be overturned. I think implicit in it was an assessment that these claims, that this as a non-delegable duty as a pathway, there was no doctrinal reason why it should be precluded, and that Lepore should be overturned. So I'm not sure if that answers the question, but I'm happy to have a quick look at my notes and see if there's anything further to add to that.
You, Ivan.
Oh, thanks, James.
The two routes to establishing private nuisance that you articulated earlier in the piece, one being the defendant's use, not a common or ordinary use. The second route being if a common and ordinary use, that use was not conveniently done, and the use being conveniently done imports some concept of negligence. And you indicated that Justice Beach-Jones did not go down route one, but went down route two, where the other justices went down route one. Is it possible that the finding of nuisance can be established at different dates, whether you go down route one or route two? Because if route one encompasses the fact that constructing a light rail per se is not a common or ordinary use, then is the nuisance established at the time when the construction commences, as opposed to because the lack of commonality or ordinary use is per se the construction of a light rail?
You know what? I actually think there's some level of ambiguity in the judgment on this, because, as I said, the Gordon and Edelman judgment is the most detailed, and it's sort of, as I said, it's kind of has the character of a principal judgment, but they don't make clear that they don't talk about unreasonable use of the land in their final analysis, although they talk about it in the discussion. So as I understood what they are saying, and to a degree what the Chief Justice and Justice Jago are saying, inbuilt in this notion of common or ordinary use is whether the use was unreasonable or not. But then it follows, though, that when you look at whether the construction was not conveniently done, surely that's got the question of unreasonableness arises there as well. So I think there's an element of ambiguity in the analysis. Having said that, the issue is kind of picked up subsequently in the also in the defence of statutory authority. So you can have and that is to say that if the creation of the nuisance is shown to be inevitable consequence or reasonably necessary from the exercise of a statutory power, then there is no nuisance. And on the facts, so ultimately you kind of end up in the same position at the point in time that in terms of what you can recover, the nuisance, broad, vernacular or broad language, the nuisance commences at the point in time that it became unreasonable for them to be conducting the construction works for one reason or the other.
But that in itself could be at different times. It could be a different time for unreasonableness that applied to Hunt River in George Street versus when.
Yeah, I can see that. I think you're absolutely right there, because I mean, even as I said, George Street was 500 days out, and Anzac Parade was 800 days out, where it's certainly in the point where the restaurant was. So, yeah.
Alison, a question for you. You put as part of your concluding thoughts that in the meantime, pathway to justice for victims of institutional abuse, particularly in clergy cases, has been opened.
Yeah.
I take it that the AA and the significance of it will lead potentially to settlements being reopened. Claims being reopened. Is it retrospective?
It's retrospective in the sense that any development in the common law has retrospective effect, but its effect on settlements, I'm not sure how it is going to impact settlements. Certainly there has been legislation passed in relation to reopening settlements in vicarious liability. And it's a very good question. I'll have to give some thought to whether the scope of the legislation that's been passed that was specifically in relation to vicarious liability, so legislative responses to overturning the decision in Bird, whether this now will fall within the scope of that. I mean, it's certainly clear. I know through my presentation I tried to identify some of the things that I think are going to require further thought. I meant to say that certainly, clarity in the law is a good thing, and we now do have a clear avenue for victims of institutional child abuse to claim that was not open in Australia, even though it was open in the UK, by means of vicarious liability. So even though the High Court wasn't prepared to develop vicarious liability to akin to employees, much of that that difficulty is now resolved in this way. We have a clear ratio. I think the issues are going to come in its application and testing on particular facts.
And Matt just mentioned that, in fact, in two recent abuse mediations, literally in the last 2 weeks, there have been amended position papers and settlements. Obviously, I can't say anything more than that. At a level which was possibly unexpected if had it been 6 weeks ago.
Absolutely.
No, well, that's interesting to hear. Alison, I've got a number of questions for you, but perhaps I'll try and limit it to one or two. It sounds to me, especially when you looked at the basis of the judgment, that this decision will have an impact potentially beyond mere just historical sexual abuse cases. That it will have a broader impact.
Absolutely. Yeah, no, that's right. It's certainly changed the scope of non-delegable duties more broadly. Certainly those practising in institutional abuse law are very aware of the change that it's now brought to that practice area, but it's not limited to that category. It's a more fundamental change to the scope of non-delegable duties and potentially to negligence.
Sure.
So even broader.
The other thing, you touched upon the High Court's decision in Bird then and also just a moment ago. I mean, I was kind of surprised that they didn't take the step with Bird, but they've taken the step with AA. That seemed, on one view, counterintuitive, but it is what do I know? I'm not the High Court. You also mentioned that we know that some jurisdictions, I think Victoria, with WA, are legislating to deal with the impact of Bird.
Yes.
What is the government doing in New South Wales? Do we know?
Well, to date, very little. So the legislative reforms have been passed in Victoria, in the ACT. The Western Australian government chose a different route. They have created a clergy liability. They haven't legislated in a way to overturn Bird in the way that the ACT and Victoria have.
Okay.
But New South Wales has not yet moved on the retrospectivity.
And just to follow on their point of legislative reform, is there a reason why New South Wales is dragging the chain, as it were, on this? Or
I'm not aware of one. I've made submissions, as have many others. The argument, as I've put it and others have as well, is that whilst legislation is generally prospective, specific legislation to reverse a decision of the High Court, which had it been taken, would have had retrospective effect. And where the scope of that legislation is limited to reversing what the High Court did, there are significant arguments that would support allowing retrospective operation of those reforms. But we haven't seen any action in New South Wales yet.
Jackie, I think you said you indicated you've got a question from a YouTube participant.
So the question is, I don't believe TF New South Wales contractors were joined as a party. Did the bench discuss at all whether this would be preferable to the competing?
No, they didn't. And bear in mind that the essence of private nuisance is that it's essentially must be brought against a landholder. So the contractors, I don't know, I can't remember the name of the company, they're not a landholder as such. So they owed contractual duties to Transport for New South Wales. They didn't owe contractual duties to Hunt Leather and the business operators. You could mount a case that they owed other common law duties, whether potentially ones in negligence, but that's it's a hard road to plough, so to speak. So in terms of private nuisance, it must, if we look at the elements of private nuisance, we're talking about a defendant's use of land, essentially. So the contractors, whilst they're part of the story, they're physically necessary to create the chaos. The right of action in private nuisance doesn't lie against them.
Alison, AA appears to be very troubling, concerning. I think you've teased that out. Two things have occurred to me as being critical to the majority reasoning. One is this concept of the duty of priests to engage with parishioners.
Yeah.
And another seems to be a place thing that occurred in or on parish land. So are we to understand that if this priest had met with these boys at a local cafe that had a rear pinball room and the assault took place on non-parish land, that the liability would have failed because it was non-parish land?
It's a very good question. The majority judgments identify the duty in largely overlapping but slightly different ways. So I think the broadest articulation is in I think Justice Gordon's judgment in talking about the function of engaging with parishioners. So that's not limited, doesn't appear to be limited to church grounds. It is difficult, I think, to work out, if we were looking at this through a vicarious liability lens, where do you draw the line between opportunity and occasion if you're describing functions at the level of one of your tasks is to engage with people. It makes that very difficult. I think on the facts of this case, because it did occur on presbytery grounds, and it was found that the priest was allowed to meet with people on church grounds, that they used that fact to build the case of liability in this particular case. But I don't think the reasons make it clear as to whether liability would have been excluded if the wrongdoing had occurred next door. So it's, yeah, I agree with you. It is difficult, I think, to work out how now to apply these provisions.
Well, I think as we inch closer to 7 p.m, it's possibly time to wrap it up. Thank you, everyone, for attending, whether you're here in person or online. You know, if you have any other queries, feel free to send an email, whether it's to Jackie or myself or Alison directly. Thanks again, and enjoy the rest of your evening. Cheers.
Thank you.
Thank you.